Imagine signing this massive, multi-million-dollar supply deal in Southeast Asia. You're sitting across from the director of the company, you shake hands, the ink dries, and you walk away celebrating.
Biggest feeling in the world, right?
Exactly. But legally speaking, you might be completely unprotected.
Yeah.
Because without even realizing it, you maybe just traded really expensive autographs with the wrong person.
Okay.
And your entire contract, it's completely invalid from day one.
Yeah, that happens way more often than you'd think.
Right. So today we are doing a deep dive into the hidden traps of Vietnamese contract law. And for you, the listener, we've pulled together this incredibly comprehensive stack of legal advisories, government news portals, and updates from some of the top law firms in Vietnam.
We're talking lawyers, PLF, SBLA, Longfan, ACSV, and FPT. It's quite the collection of sources.
It really is. And the legal landscape in Vietnam right now is undergoing this dramatic shift.
Oh, absolutely. Navigating it requires a very specific kind of precision.
And that brings us to our mission today. We want to equip you with that exact precision. So whether you're a seasoned investor making moves in the region, a curious entrepreneur, or honestly, just someone tired of signing things they don't quite understand.
Which is most of us, to be fair.
Right. Today's deep dive is going to transform what looks like a dry legal document into this fascinating roadmap of strategy, risk, and ultimately, the technological revolution of the 2023 law on e-transactions.
Because to understand where digital contracts are going, in the future, we first have to master the foundational building blocks in the physical world.
Yeah, we have to look at exactly where most people accidentally sabotage themselves before the ink is even dry.
Exactly. And if we look at the insights from lawyers, Vietnamese civil law demands this incredibly high degree of structural rigidity. I mean, you can't just write up a casual letter of intent on a napkin and expect it to hold up in court.
They want specifics.
Very specific. The law requires explicitly defined pillars. So there are 8 mandatory contents of a contract.
Okay, lay them out for us.
Sure. You need information on the subjects, the object of the contract, so, the actual goods or services, quantity and quality, price and payment methods.
That's 4.
Right. Then you need the term, location, and method of performance. Plus, rights and obligations, liability, and finally, dispute settlement.
Okay, let's unpack this. Because a contract is kind of like a recipe, right?
Mm-hmm.
If you leave out the baking powder, like the exact payment term or the specific location, the whole thing just falls flat when the heat is turned up.
That is a perfect analogy, yeah.
Let me push back on that very first requirement you mentioned, information on the subjects. Does it really matter exactly who signs it? As long as they, work for the company and have some kind of C-suite title.
Well, what's fascinating here is that you've just walked into one of the most common and honestly most devastating legal traps in Vietnamese business.
Really? Just from the signature?
Oh, yeah. The Longfan advisory explicitly highlights this as the wrong representative trap. People naturally assume, and quite dangerously, I might add, that a company's director or general director is automatically the legal representative.
I mean, it says director on the business card.
Right, but under the 2020 enterprise law, it depends entirely on the corporate structure.
Wait, so the title of director doesn't automatically grant you signing authority?
Not necessarily. So for a joint stock company, the legally recognized representative might actually be the chairman of the board of management.
Oh, wow.
And in a private enterprise, the representative is the owner. So if the director signs your contract, but the enterprise registration certificate lists the chairman as the rep, and there's no documented power of attorney,
But tell me.
you don't have a contract, the agreement is void from the start.
That is genuinely terrifying. It's just
Mm-hmm.
a simple administrative assumption, but it completely voids the entire business relationship.
Yep. Your multi-million-dollar deal is just a worthless piece of paper.
Are there other structural traps like that just hiding in the drafting phase?
Oh, definitely. Another major issue Longfan points out is relying on expired laws. Vietnam's legal frameworks update pretty frequently to keep pace with their economic growth.
Which makes sense.
Right. But you might see a contract drafted today that cites the 2012 labor code instead of the 2019 version.
Drafting a contract with an expired law is basically like trying to plug a modern appliance into this obsolete, deactivated power grid. Like the physical structure is there, but no legal authority is actually going to flow through it to power your enforcement.
That is precisely how it functions. When a dispute happens, the court looks at the governing law you cited. If it's superseded, those specific clauses might be completely unenforceable.
Man, precision really is everything.
It is. And it applies to language, too. To a lawyer using vague language like within a reasonable time or promptly, That instantly creates legal loopholes.
Because reasonable is subjective.
Exactly. Reasonable to you might be 48 hours. Reasonable to a struggling supplier might be 2 months.
Right. Okay, so let's say you've drafted the perfect contract, you got the right representative, you cited the right laws. But the reality of business is that sometimes people just don't deliver.
Delays happen, promises get broken.
And when they do, who actually pays for it? The math here isn't what most foreign investors expect. Let me bring up a highly specific mathematical example from the Chinfu, the government news portal, just to test you on this.
All right, I'm ready. Let's hear the scenario.
Okay, imagine you're buying 10 printers at 10 million Vietnamese dong each and 10 computers at 20 million dong each.
Got it.
The contract has a standard penalty clause. If the supplier is late, they get penalized 1% of the contract value per day.
Very standard, yeah.
So the supplier messes up, they're late delivering 5 of the printers by 5 days. And they're late delivering 5 of the computers by 100 days.
Okay, so 5 printers, 5 computers.
Right. If you do the raw math on that 1% daily penalty compounding over 100 days, the penalty comes out to roughly 102.5 million dong.
Yeah.
But legally, they don't actually have to pay anything close to that, do they?
No, they do not. And this is a massive shock to a lot of investors. Under the 2005 commercial law, penalties for commercial contracts are strictly capped at 8%.
But 8% of what?
8% of the value of the breached portion of the contract.
The breached portion.
Yeah.
Not the total value.
Correct. You received half the printers and half the computers on time, right?
Yeah, 5 of each were on time.
So the law only looks at the value of the goods that were actually late. 5 printers at 10 million is 50 million dong. 5 computers at 20 million is 100 million. The total breached value is 150 million dong.
Okay, so the absolute maximum penalty the law allows is 8% of that 150 million.
Exactly, which is 12 million dong.
Wow. So it doesn't matter if your contract explicitly says 1% a day, and it doesn't matter if both parties willingly signed it. The law just artificially caps it at 12 million.
It does. Regardless of what daily percentage agreements you made, that might add up to over 100 million.
That is wild. I mean, isn't 8% incredibly low? If I'm a supplier and I find a better deal elsewhere, why wouldn't I just intentionally breach the contract, gladly eat the tiny 8% penalty, and take the better deal?
Well, if we connect this to the bigger picture, you have to understand the difference between a penalty for a breach and compensation for damages.
Okay, explain that.
That 8% is just the penalty. It's meant as a deterrent. But the injured party can also claim unlimited actual damages on top of that.
So I can still sue to get my money back for the chaos they caused?
You can. But, and the Espel advisor makes a huge point of this, winning a claim for actual damages is notoriously hard to win in practice. You have to definitively prove 3 things.
What are they?
First, the breach itself. Second, the actual physical or financial loss. You need hard receipts.
So I can't just claim, like, brand damage or generalized stress.
Exactly. No generalized claims. And third, you must prove a direct causal link between their breach and your loss. If the court thinks external market factors contributed to your loss at all, they might just reject the whole damages claim.
Wow. So winning those extra damages is a real uphill battle.
Yeah.
Now, is that 8% cap universal for every contract in Vietnam?
No, and that's a vital distinction. That cap only applies to commercial contracts. If it's a civil contract, meaning it's not for profit between businesses, there is no 8% cap. You can agree to any penalty you want.
Okay, that makes sense. So we've covered what happens when someone breaks a contract because they're sloppy or calculating. But what if the failure wasn't out of malice? What if, a global pandemic shuts down the entire supply chain?
Right, moving from calculating fault to dealing with the uncontrollable.
Exactly. Which brings us to force majeure. It often sounds like the ultimate, the dog ate my homework excuse for businesses. But legally, the dog actually has to exist, and it has to be a Godzilla-sized dog.
That is an incredibly apt way to visualize it. You can't just claim force majeure because market conditions got tough. The criteria are very strict.
What does the law actually require?
Well, it must be objective, so entirely outside the party's control. Second, it has to be completely unforeseeable at the time of signing.
Which makes timing everything.
Yeah.
Like signing a contract in December 2019, a global lockdown was unforeseeable. But signing that same contract in June 2020.
It was an established reality by then, yeah. Third, the event must be unfixable despite taking all necessary measures. And fourth, it must be the direct cause of the breach. If you meet all four, you're relieved of liability.
Okay, but how does that differ from hardship? That was an idea that became incredibly relevant during COVID-19.
Right, hardship is governed by Article 420 of the 2015 Civil Code, and it doesn't mean performance is impossible.
Like it is with force majeure.
Exactly. With hardship, performance is still possible, but it's become excessively burdensome due to a fundamental change in circumstances.
Like the cost of imported steel tripling for a builder.
Precisely. And while force majeure automatically pauses or terminates obligations, hardship requires the parties to attempt renegotiation.
And if they fail to reach a new deal,
Then a court can step in to amend the contract. But, importantly, they'll only do that if terminating the contract would cause even greater financial damage.
got it. Okay, so let's follow this progression. Force majeure fails, hardship renegotiations break down, and penalty limits are being fiercely contested. At this point, the parties are going to war. But where exactly is the battlefield?
Dispute resolution. The clause everyone ignores until they desperately need it.
Right. Now, the default movie-style threat is, I'll see you in court. But in Vietnamese business, it's not quite that simple, is it?
Not at all. You generally have two main paths: the courts and commercial arbitration.
Arbitration's private, right?
It is, and it's often preferred for business. But there's a catch. It only works if both parties explicitly agreed to it in writing beforehand. If you didn't, the court will just reject your attempt to use arbitration.
Okay, so let's say we're going to court. I want to point out a major drafting error that the PLF source highlighted. You can't just write XYZ District Court into your contract because you like them or they're close to your office.
Oh, absolutely not. The courts have strict territorial jurisdiction. It's usually based on where the respondent, the person being sued, resides.
So if I'm in Ho Chi Minh City suing a supplier in Hanoi, I'm flying to Hanoi.
Yep. Unless the dispute involves real estate, then it's exclusively the court where the real estate is located.
Okay, but what if the listener is trading across borders? Say, an American company buying from a Vietnamese manufacturer.
For international sales, you can use a choice of law clause. You can use international frameworks like the 1980 Vienna Convention, Incoterms 2020, or UCP 600.
Or even a foreign national law, right? Like New York law.
Yes, exactly, provided it doesn't contradict the basic principles of Vietnamese law. And again, as long as it doesn't involve domestic real estate.
Okay, here's where it gets really interesting. We've established how to write, enforce, and fight over a contract in the physical world. But the physical world is rapidly becoming obsolete.
It really is. The 2023 law on e-transactions is going to change everything.
Right, and it takes effect on July 1st, 2024. The FPT source points out this incredibly practical benefit right away. Paper contracts can be destroyed by fires or eaten by termites, but e-contracts, they are immune to physical force majeure events.
Termite-proof contracts. I love that. And the new law expands digital transactions into deeply personal areas that used to be strictly banned from e-formats.
Like what?
We're talking land use rights, inheritances, birth and death certificates. Even marriage and divorce can now be handled digitally.
I have to push back on that. If I'm buying land digitally, how do I actually know the signature on my screen is real and not just, a copied image pasted onto a PDF?
Well, the ACSV source breaks this down perfectly. The law creates 3 new classifications of legally valid e-signatures to prevent exactly that.
Okay, walk us through them.
First, you have specialized e-signatures, which are for internal use and require registration with the Ministry of Information and Communications.
That's it.
Second, you have public digital signatures. These are certified by licensed organizations acting as a third-party guarantor. And third, specialized e-signatures for public service, which are used by government agencies.
That's a lot of infrastructure just to prove who signed it. But what about proving when they signed it?
That's where trust services come in, things like timestamping and data message certification. They mathematically prove that a document existed in a specific state at an exact millisecond in time.
Oh, wow. So you completely eliminate the he said, she said arguments.
Completely. And maybe the most exciting part is the new open data regulations.
How does that work?
It allows the public to access and use state data without restriction. For example, the National Business Registration Portal.
Wait, really? So before I sign a contract, I can just log on and verify exactly who the legal representative is?
Exactly. It completely solves that wrong representative trap we talked about earlier. It fuels much better, safer business strategies.
That is incredible. So just to wrap this all up, look at the journey we've taken today. We went from ensuring the correct company rep signs the paper to navigating that tricky 8% commercial penalty cap.
We survived force majeure and hardship.
Right. We figured out how to fight in the correct legal jurisdiction. And finally, we migrated all of this into the termite-proof digital future of 2024. Yeah.
It's a lot of ground to cover, but the listener is now armed with the foresight to avoid those common contractual traps.
And they can leverage these new digital tools to protect their investments and relationships in Vietnam.
Absolutely.
Which leaves me with one final provocative thought for you to ponder. If the 2023 law on e-transactions means that our marriage, divorce, and death certificates are now entirely digital data messages, and with automated information systems now legally allowed to execute contracts without human intervention, how long will it be until the entire legal life cycle of a human being and all their business disputes are entirely managed, negotiated, and perhaps even judged by automated algorithms rather than human courts?
Well, that is a profound question. We are definitely heading toward a very different legal frontier.
We really are. Thank you for joining us on this deep dive. Until next time.